Let's go on the record on cause number DC 1914120, McMillan versus Navarrete. Counsel, make your appearances.
Jeff Shelton for plaintiff, Ben McMillan.
Your Honor, Chase Garrett for defendant Earth Motor Cars, LLC. My associate, Margaret Ricky, may log in from another location at some point.
Do you want me to wait for her? Because it's not the start time yet. I think she's not late.
No, Your Honor, I think she's just going to watch. She helped draft the motion and just wanted to watch, I think.
Okay. All righty. Well, let's get started then.
Okay. Your Honor, we have filed two motions that are set this morning. If I may, I'll just sort of have an omnibus argument covering both motions and then turn it over unless the court would have me do it otherwise.
That's fine.
Okay. This is a claim that should have never been brought against my client, Earth Motor Cars. The court has a scheduling order in this case that sets the deadline to add new parties August 1st, 2020, without moving for leave and showing good cause. My client was added to this lawsuit in March of 2021, well outside of that deadline. We have moved to strike the first amended petition that adds Earth Motor Cars to this lawsuit. Even as we sit here at this very moment, the plaintiff does not have a motion for leave on file. The plaintiff has not shown any good cause for adding Earth Motor Cars this late. The closest thing I have to that is in their response, they say, well, Earth Motor Cars isn't bound by that scheduling order, which may be true. However, the plaintiff certainly is bound by that scheduling order because the plaintiff agreed to it and the court ordered it. At this late stage, if you look at the scheduling order, discovery is closed. The case had already been on one trial setting. It's just far too late to add a new defendant to the lawsuit. I think for that reason, the court would not abuse its discretion in striking the pleading, which dismisses my client. However, even on liability grounds, this is a case they should have never been brought into. Earth Motor Cars is a dealership in Carrollton. They sell used luxury automobiles. Defendant Ivan Navarrete is the person that was involved in the motor vehicle accident. He is a co-defendant. He's represented by Brad Westmoreland. At Earth Motor Cars, his job is in finance. So when you go purchase a vehicle, the salesman kind of hands you off to the guy at the computer who prints the forms and signs them. And this person tries to sell you a warranty and all those fun things. That's what Mr. Navarrete was doing for Earth Motor Cars at that time. He was not provided a personal vehicle to drive. He was not authorized to make any trips outside the dealership in furtherance of his job. He simply checked a vehicle out of Earth Motor Cars inventory because he was interested in purchasing it for himself. All those facts are absolutely uncontroverted. Mr. Navarrete checks a vehicle out on a Saturday when he completes his shift. He signs a borrowed vehicle agreement, making it clear that he was borrowing it, using it for his personal use. The accident in question occurred at 10 o'clock at night on a Sunday. He was not within the course and scope of his employment. He wasn't doing anything in furtherance of his employment. Earth Motor Cars isn't even open on Sundays. They're not open at 10 o'clock at night, and they never would have sent Mr. Navarrete into uptown Dallas. He simply was test driving the vehicle for his own personal use. The case law is pretty clear on that he's not in the course and scope of his employment. He wasn't doing anything to further Earth Motor Cars business. We've cited case law. So when you look at employer-owned vehicles as a basis for respondeat superior liability, if the employee is off duty and is driving the employer-owned vehicle for social purposes, which that's what's happening here, that's uncontroverted, then there is no vicarious liability. They've also alleged in their response, well, he was test driving it, so maybe he was furthering their business. We've cited the court to case law that says in the context of a test drive, the dealership that owns the vehicle is not responsible under respondeat superior liability or negligent entrustment because they can't be in charge of ensuring that everyone that test drives a vehicle can and will be safe. There's just no foreseeability as a matter of law. Now, we've cited the court a 1993 case from the Dallas Court of Appeals This is factually and legally analogous to what happened in this case. This case came from the 193rd District Court in Dallas. A salesperson at a dealership took a vehicle home over the weekend and drove it around. He drove it up. The dealership was in Dallas. He drove it to Plano to meet a friend. In fact, he puts his friend behind the wheel and says, "Hey, you should drive this because I think you're going to like it." And the 193rd District Court in 1993 grants summary judgment on respondeat superior and negligent entrustment because it was not in the furtherance of the employer's business. It was on a weekend. And they've also held that in the context of a test drive, the prospective purchaser is not acting for the benefit or on behalf of the seller. He is acting on behalf of himself. And so if Mr. Navarrete was driving Earth Motor Cars vehicle, it was for himself and it was not for the dealership. And that's what the case law holds. We've also attacked on a no evidence ground. We've attacked every element of their claims. Their evidence can be summed up in sort of two different categories of documents. It's about 13 pages of evidence. They attach a copy of the accident crash record itself, and they also attach a transcript of Mr. Navarrete's driving history. Those things do not create a fact question here. Those things do not controvert the uncontroverted evidence, which is two affidavits, one from the owner of Earth Motor Cars, who says that he's not authorized to make trips for the company. His job's at a desk. The other affidavit is from Mr. Navarrete himself, who says he checked out the vehicle from inventory. He did it at his own risk, and it was a purely social and personal trip when the accident occurred on Sunday night at 10 o'clock. So we think we've established really three grounds for the court to grant summary judgment. There's the motion to strike. There's traditional grounds on respondeat superior and negligent entrustment. The no evidence grounds, they don't attach any evidence that creates a scintilla, much less the type of evidence that is required to create a scintilla. We think that summary judgment's appropriate, and I would ask that my client, Earth Motor Cars, be dismissed from this lawsuit this morning. Thank you.
Response?
Yes, Your Honor. I'll start with the far-fetched motion to strike argument. My firm got this case referred to us after the deadlines Mr. Garrett is referencing. When we took a look at it, we saw that Earth Motor Cars was the owner of the vehicle, so naturally we amended the lawsuit. We also got a continuance from the initial trial setting. During that continuance, talking with Mr. Westmoreland, we certainly intended to amend the scheduling order. The court granted our motion for continuance. Trial is set March of 2022, 8 months from now. In their motion to strike, they point out the grounds for a motion to strike. The court has to find that Earth Motor Cars was surprised and that they are prejudiced. So first of all, they're not surprised. Mr. Navarrete still works for Earth Motor Cars. They know he was involved in a wreck in one of the cars they owned, and they let him drive. And they're not prejudiced because we've got 8 months until the trial date. There's still plenty of time to amend a scheduling order and conduct additional discovery. So of another important note, Your Honor, the statute of limitations in this case doesn't run until July 21st next month. So I can simply dismiss it and refile it. And so this procedure.
I'm not concerned with that. I'm going to go ahead and grant you leave to add.
Okay.
I'm not concerned with that. So let's get to the merits.
Okay. In our response, Your Honor, we point out, well, first we'll point out that the alleged evidence Mr. Garrett is referencing are just self-serving affidavits. And as such, they are no evidence at all for summary judgment. It's the owner of a company saying, we didn't do it. And it's the employee of the company saying, oh, I agree with the owner, my boss who pays my check. So they're self-serving affidavits. But despite that, when we look at the driver agreement supplied, there is a portion of the driver agreement that is evidence that Mr. Garrett supplied in filing a summary judgment, where they're supposed to fill in a credit card number if someone is taking a regular test drive. In that spot is written, employee, no card needed. Well, that is that is a scintilla of evidence to suggest this wasn't a normal test drive. This wasn't a normal situation. That's a scintilla of evidence to suggest both, um, to suggest course and scope, Your Honor. As to the negligent entrustment, well, I'll point out as to the no evidence summary judgment, which I think technically is what you're supposed to consider first. There's not been sufficient time for discovery. This case was filed in March, trial's not till next March. There's not sufficient time for discovery. But we have presented evidence of negligent entrustment, or a scintilla of negligent entrustment, which is through the police report, the certified copy of the police report. It's clear that Mr. Navarrete caused the accident, was negligent, and the negligence caused the injuries. And then we look at his certified driving record, and all Earth Motor Cars wants to rely on is, we didn't know, we didn't know, we didn't know. But that's not the end of the inquiry. It's reasonably should they have known. Okay, it's did they know or reasonably should they have known. And given his driver history that we see, given his arrest record that we see for an arrest for 10 years for a controlled substance, there's an argument to be made that a jury could certainly find that Earth Motors Cars should not have entrusted Mr. Navarrete with one of their vehicles. It's also important to know that Mr. Navarrete left the scene of the wreck in Uptown at 10 p.m. And there's a companion criminal case looking into those matters. But here we have evidence that we have presented through Earth Motor Cars themselves, their employee, the borrowing form, and the driving record and police report to suggest that the course and scope and the negligent entrustment cases, summary judgment should be denied on this.
So let me ask you this. So, Mr. Shelton, are you moving for a continuance of the summary judgment so you can take additional depositions, or are you wanting me to make a decision today?
Well, Your Honor, I suppose, yes, to be procedurally correct, we will move to continue the summary judgment so we can conduct additional discovery. I think on the face of the summary judgment, though, it still fails. But yes, we would like the opportunity to take additional discovery.
Response?
Your Honor, I think if they move to continue at summary judgment hearing, they're going to have to show the court the materiality of what they're hoping to get. They're not going to find anything that changes the fact that this accident occurred on a Sunday at 10 o'clock at night when Earth Motor Cars was closed, when their finance manager does not and cannot go outside of the dealership to perform his job. So taking depositions isn't going to change those facts, which are in concrete. Taking depositions.
I mean, I guess, Mr. Garrett, I see this somewhat analogous to a situation. Let's say you have someone in your household that I've had this issue come up a couple of times, more than a couple of times, as a judge, where you have somebody in your household that you know is an alcoholic and is a dangerous driver, yet you leave your keys out, they take the keys and get into an accident, and that can be a basis for negligent entrustment. Why in this situation, if this guy was a dangerous driver and they didn't take any precautions to secure their vehicles and they knew that he could take vehicles, that we wouldn't at least have a fact issue as a negligent entrustment?
No, because you have to show that Earth Motor Cars anticipated that an injury would occur. There's nothing about his driving history or the fact that he has a felony from 10 years ago that would suggest that he shouldn't be able to test drive a vehicle. And so we've cited the court, the Young Chevrolet case. That case disposes of negligent entrustment and disposes of respondeat superior liability under almost the exact same facts. In fact, in that case, in the case where the summary judgment was affirmed, that person was intoxicated and was subsequently prosecuted for being intoxicated. And they said that that wasn't enough to show that the dealership should have known that that person could have caused an injury.
Mr. Shelton, how do you distinguish that case?
That case is distinguishable because I agree with what Mr. Garrett said. The fact he was drunk that day that he caused the wreck, yes, an employer or the entruster does not know about that, but it's the second element, Your Honor, reasonably should have known. And if this Earth Motor Cars had made any investigation into his driver history, they failed to do that. They didn't do that. They said, here, take a car, because he wants to buy it, maybe. So it's distinguishable on those grounds because there was no discussion in that Chevrolet. That case does not end negligent entrustment for test drives. It doesn't do that. It ended the negligent entrustment claim in that case because the court found that dealership could not reasonably have known or should have known about the driver's driving record. I don't think that driver had a history similar to what Mr. Navarrete has through his driving record.
Just simply no basis to tell car dealerships that they have to examine and vet every person that wants to test drive a vehicle. Like the case said, the Young Chevrolet case says, when someone takes a vehicle, they're acting on their behalf and not on behalf of the dealership. They're acting in their interests, not in the interests of the dealership. So if what Mr. Shelton is urging, this creates an onerous burden on every dealership in the state of Texas to sit down and, investigate someone before they let them test drive a vehicle. And that's simply not required. There was nothing, he had a valid driver's license. They had no reason to suspect that he was a bad driver because he didn't drive vehicles as part of the course and scope of his employment ever. He did his job at a desk. So there's simply no reason for.
How was he able to get the vehicle? I guess that's what I'm unclear about. How did he?
In the affidavits, Your Honor, he was interested in purchasing this vehicle. He went to the dealership.
He worked for the dealership and he was interested in purchasing it.
He was interested in a personal purchase. He signs a borrowed vehicle agreement, taking the vehicle out of inventory. He had permission from the dealership to take the vehicle out of inventory for an overnight test drive. Anytime someone does an overnight test drive, the dealership makes them fill out this borrowed vehicle agreement and says, you're going to return it.
But they didn't check his driver's license because he was already an employee.
Oh, they actually got a copy of his driver's license. And so in the form, it says that he represents that he has a valid driver's license. And so they got a copy of his driver's license. They took the information down and they did it just as if he were a prospective purchaser who came, that Saturday during business hours. He filled out the form. He took the vehicle. He assumed all the risk in test driving it. There's just simply no reason for Earth Motor Cars to have tried to obtain a transcript of his driving history. Frankly, if you look at the driving history transcript, you don't see anything that would probably not make me or you or anybody else, a threat to society. I mean, he's had one or two minor accidents in the total time he's been driving, and 2 or 3 speeding tickets. We're not talking about someone that just every time he gets behind the wheel of a car just hits someone else. So I don't think they're under the obligation to do it. Like I said, he had permission to check it out for that purpose. He turned the vehicle back in on Monday. It was damaged. He didn't want to buy it. The dealership didn't want to sell it to him. So the deal never happened. But
Your Honor, I will distinguish one thing. It is important. Mr. Navarrete is not a stranger coming in off the street talking about buying a car. He's an employee of Earth Motor Cars. He's still an employee of Earth Motor Cars. This wasn't like any other test drive because we see on the face of the form where it says, give me your credit card number, is written employee, no card necessary.
Yeah,
so that's another.
They can take, if he damages the car, they could take it out of his check. I mean, they didn't require him to put a credit card down. That doesn't create a fact question on course and scope for the respondeat superior claim. They didn't make him put a credit card down. That doesn't mean that Earth should have known he was a bad driver. It doesn't change.
I don't know. I guess in my mind, there's a lot of unanswered questions here about what exactly he was doing. And you've never taken his deposition, Mr. Shelton?
No, Your Honor, we have not. We've been involved in this dispute pretty early on. I mean, like I said, we filed at the end of March and they filed this a month later, and we're just getting to the hearing date now.
All right, Mr. Shelton, I'm sorry, go ahead.
I was going to say we need discovery, but go ahead, Your Honor. I'm sorry.
Yeah, I think you need discovery too. So I'm going to go ahead and grant the continuance, and then we'll kind of take it up once you guys have finished. So you need to take his deposition. What other discovery do you need?
I just need to get his employee file. I need his deposition, and then probably the owner who gave the affidavit's deposition to see, you know, how they're claiming things really work. And this isn't, you know, we're going to these links because this isn't a $15,000 soft tissue case, Your Honor. Mr. McMillan's already had a spinal fusion, and he's in his 30s. He's lost the tip of his thumb and is losing feeling in his hand. So we're going to do a little bit more than we do sometimes on some of the smaller cases. But that's what I need. I need primarily just his employee
move
file.
expeditiously. Okay.
Yes, sir.
Anything else, guys?
Your Honor, so if I understand the court's ruling correctly, we're just going to continue this hearing, take some depositions, and then revisit.
Revisit it at that point.
Okay. Understood.
Okay,
Thank
guys.
you.
Thank you.
Thank you, Your Honor.
You guys are excused.
Thank you.
Ms. Shea, what are you here for?
Hi, Your Honor. I was here with Chase Garrett on behalf of Earth Motorcars. I just came in a little late.
You did the briefing?
Yes, I did.
Good job on the briefing.
Thank you, Your Honor.
You should, Mr. Garrett should give, did he already leave? Okay, he should give you a pat on the back. That was a good job.
I'll let him know. Thank you so much.
Thank you. You have a good day.
Bye.
All right. Let me turn off YouTube.